My name is Elizabeth Hecht, and I'm a consultant here at Turner & We are joined today by colleagues from Trowers Hamlins. This is the Retrofit Information Support and Expertise RAPT event, which is fully funded by the Department of Energy Security and Net Zero, delivered by Turner & Townsend. So today we'll be going through the legal considerations in Retrofit for projects with Trowers Hamlins. They'll do a quick introduction to themselves and then discuss areas such as Warm Homes Social Housing Fund, look at grant funding agreements and data sharing agreements. They'll also look at consortia agreements, subsidy control, and public procurement considerations. And then finishing up with leaseholder considerations as well. So I'll now hand over to the team presenting today, and you'll hear from Ruby, Jessica, Stuart, and Lindsay. Over to them.
There's three main documents: the grant funding agreement, data sharing agreement, and also a grant offer letter. At the moment, DESNZ has published a template grant funding agreement and data sharing agreement on their website. So all of our comments in the presentation today is based on the template published. But again, there might be some amendments when you actually get the specific grant funding agreement and data sharing agreement that's tailored to your organization. As a general note, we should flag that these terms are generally non-negotiable with DESNZ, but it's still important that you understand what your obligations are under these documents and where any potential risks lie and how to mitigate these risks. So if we move on to the kind of key terms you need to be aware of in the grant funding agreement, one of the key changes for Wave 3 is that the funding agreement now talks about different approaches for challenge fund applicants and strategic partnership applicants. So, for example, challenge fund applicants have specific kind of processes to follow with the phase requests, and strategic partnership applicants have specific processes to follow in respect of how they deliver the works. And also, there's also reference to kind of a self-conducted evaluation process that is compulsory for strategic partnership applicants, and optional for challenge fund applicants. Another key term to flag is just the delivery and timescale set out in the grant funding agreement. Funded activities are required to start within 6 weeks after the commencement date. When you're actually delivering the works, you have to comply with the KPIs and milestones that are set out within the grant funding agreement. And a point to note as well for challenge fund applicants, these KPIs and milestones may flex or may be specific depending on each phase. So again, you have to be aware that it may not be the same set of KPIs for each phase that you apply for. And finally, the works will need to complete by September 2028. In terms of monitoring and reporting, so similar to previous waves, this will still require monthly reporting. There's quite a prescriptive list in Wave 3 on what you have to report against. And again, as mentioned previously as well, there is that self-conducted evaluation for strategic partnership applicants, where you have to provide this evaluation at the start of the funding period, during the funding period, and also at the end of the funding period. Another key issue to flag is the events of default. So like in previous waves, there's quite a wide range of circumstances that could trigger an event of default. These are particularly notable because if they're triggered, DESNZ has the potential to terminate the grant funding agreement, claw back funding, or withhold or suspend future funding. So again, you just need to be very aware of what items could cause an event of default, and again, how to mitigate against these events. There are a few indemnities and liabilities in the grant funding agreement. These are quite widely drawn. We often flag these to our clients as one of the key risks in the document. It's hard to negotiate these with DESNZ, so the best way to deal with these is be aware of them, mitigate any risks, and also flow down any liability to your contractors if possible. Few provisions that have been added into the Wave 3 documents that weren't there in previous waves. So, for example, there are some step-in processes following termination, which indicate that if these arrangements terminate, a third party could come in, or DESNZ could come in and potentially complete the funded activities. That's something that's worth clarifying with DESNZ, because realistically, it may not be something you want to do as you're the landlord of the property. So you may not want a third party completing the activities. And again, there's also some new drafting on ownership of assets, which seem to indicate that DESNZ would own assets purchased using the grant until they are installed in the properties. Again, practically speaking, it might be worth clarifying that with DESNZ, because if you're purchasing materials or your contractors are purchasing materials, the current ownership wording in the funding agreement may not work with what's actually happening on site. With the data sharing agreement, I'm not going to spend too long on that because, again, normally we'd get our data protection team to advise on the specific terms. But the main things to flag is that it envisages a controller and controller relationship between you and DESNZ. So you'd both be independent controllers of the personal data of your tenants and residents. And an interesting point to note as well is that the data sharing agreement currently says it's not legally binding, which is a bit unusual. And we'd query why DESNZ would require you to sign a contract that wasn't legally binding. But again, just to flag, it was the same position in Wave 2. So I guess they're just following what they had set out on Wave 2 over here. So in terms of mitigating some of the risks, as we flagged previously, the grant funding agreement, data sharing agreement with DESNZ are largely non-negotiable. So one of the ways to mitigate the risk is to flow down key obligations into your delivery contracts with your contractors. And we've split this up into two kind of main sections. Some of these are the operational obligations that need to be flowed down, and some of them are more liability focused. But in terms of the operational points to flow down, if you're applying via the challenge fund route, you'd want your contractors to support you with providing information for phase requests, and also their support in submitting any phase requests to DESNZ. Again, in delivering the program, you'd want your contracts, your works contracts, to be clear that the contractors will be required to comply with the KPIs and milestones set out by DESNZ. And again, your works contracts would also have to be flexible enough, if you were a challenge fund applicant, to acknowledge that different phases may have different KPIs and milestones as well. Monitoring and reporting as well is a big one, where landlords often require contractor support. Again, you would just want your contractors to provide you with all required information prior to the DESNZ reporting deadlines, and to also help you kind of collate the information submitted to DESNZ. And with data protection as well, I thought it would just be interesting to flag that you do have to flow down the data protection obligations to your contractors as well. In previous waves, the DESNZ data sharing agreement specifically said that the relationship between the landlord and the contractors would be a controller-processor relationship, but that has now been removed in the Wave 3 documents. So there will be an exercise where you sit down with your contractors, analyze the information, personal data that you'll be sharing, and how that will be used. And then you'll have to determine whether that would be a controller-controller relationship or a controller-processor relationship. In terms of the liability terms or that you'd flow down to your contractors, this will be subject to commercial negotiations, how much you can flow down and what contractors will accept. But the key risks for the landlord particularly concern events of default. So as I mentioned previously, there are a wide range of circumstances that could trigger an event of default, could trigger things like termination or funding clawback. And some of these events of default would fall within the contractor's kind of action. So, an event of default can be triggered if the works aren't delivered properly or if deadlines are missed, for example. And so, again, I think, so ideally what you'd like to do is make sure that if the contractor triggered an event of default, they would be liable. Again, how much you would be able to claim from your contractor would be subject to commercial discussions, but you definitely want an acknowledgement that they shouldn't contribute to any events of default. With termination, you just want to make clear that if the grant funding agreement terminated, you may also want the ability to terminate your works contracts. And again, if the grant funding termination was due to the actions of the contractor, you'd want to be able to seek suitable recourse against your contractor. And then the final point was on the indemnities and liabilities. As flagged previously, there's some wide indemnities that you owe to DESNZ under the grant funding agreement. Ideally, you would seek to make these back-to-back in your work contracts with the contractors. So if they put you in breach, you would then get an indemnity from your contractor. Again, this is subject to negotiations and what can be agreed and the specifics of your project at the time. I'm now going to pass over to my colleague, Jess, who's going to talk about specific funding mechanisms set out in the grant funding agreement.
Thanks so much, Ruby. So, yeah, I'm Jessica Chinsky. I'm a partner at Trowers, as Ruby mentioned. I do a lot of work in grant funding, especially around sort of the affordable homes programs with GLA and Homes England. So sometimes I might reference that a little bit in contrast. And I think it's helpful because, everyone on this call, I suspect, is a social housing landlord at some level. So you've probably encountered those terms over the last, say, 15, 20 years. Now, in respect of the SHF Wave 3 grant agreement, there has been a fundamental change that Ruby actually flagged in terms of grant funding, sort of drawdown and claims and payment process. And that's the difference between the strategic partnership and the challenge fund routes. The drafting itself is not that different. I mean, there are some differences in the grant funding agreement, but there's not a lot of difference. But the impact of that change could go quite far beyond just those specific processes. And I'll explain that a little bit more. I mean, around strategic partnership process, you have this kind of quite flexible grant drawdown process where claims are being submitted at least every 3 months. And that's really helpful. It's against wider delivery. So there's a real level of flexibility there. But that in turn could put pressure on other processes within the grant funding agreement. And I'll touch base on those in a minute. Similarly, on the challenge fund, different in terms of grant drawdown, particularly because this is on a phase by phase basis. So you need to have a phase crystallized under the agreement. And by crystallized, I mean that needs to be approved by DESNES before you can actually draw down grant in any material way against it. And that's, again, that seems sort of straightforward, but you can see that it has a real impact around the potential logjam at the front end of DESNES approval, potentially, delaying the ability to draw down grants. That's really where you need to be focused when it comes to challenge fund and grant drawdown. Now, across both SP and challenge fund sort of routes, there is the ability for the funder, DESNES in this case, of course, to undertake quite significant sort of reporting requirements, to have reconciliations. Those can be every 3 months. There's an annual reconciliation, and there are significant impacts on those reconciliation processes. So if something pops up and DESNES isn't very happy with the way that expenditure has been incurred, or there's an issue, it has extremely wide ability to do things like reforecast profiling, clawback funds, particularly unspent funds within a financial year. And I just mentioned that because that goes to, for example, the additional pressure you might have in an SP route, where you may see more focus by DESNES on those reconciliation and review processes, just because of the flexibility that's allowed up front, versus sort of phase requests where there's a kind of granular oversight by DESNES. And so there might not be so much of a need to focus on the reconciliation. Worth being aware of that. The other big point around funding that's new is the co-funding requirements. Now, of course, as previously, there is a co-funding requirement. That's normal. In this case, 50% of measures need to be funded without the SHF grant. So that can come from a number of sort of places. That can be from your own resources. The agreement's even very specific. It can come from other consortium members. It could be a contribution from leaseholders. It could be on lending. That's very common. One thing it cannot be is other grant. So we know, for example, that in Homes England, AHP grant is now available for use for estate regen. That could not be combined with decarbonisation works under SHF funding. So that's important to be aware of. We do see a lot of clients, though, increasingly going towards some of the new programs around affordable homes guarantees funding from Homes England, especially as there's flexibility now to take out loans that are guaranteed for decarbonisation works. So something to think about there. Co-funding, new provisions around the minimum amount of co-funding that must be spent in each year, 10%. And there's a sort of automatic link to events of default if you fail to hit that. So that's quite, in a sense, onerous requirement. There's sort of no, remedy between that unless it's totally in DESNES's discretion. So be aware of that, and be aware that in this period that we're in now, you can start works, and that will be part of your co-funding requirement, but that's at your own risk. And DESNZ can completely refuse to approve that. It's within their discretion, within the terms of the grant agreement. So that's something to know now before you've actually entered into the grant agreement. Third-party funding, no change substantively there, but just to flag, because it's so different than, say, Homes England or GLA funding, all third-party funding must be approved in advance by the funder. So that's whether it's coming from your consortium, from leaseholders, anyone who's not signed up to the agreement, you must have that approval. So again, that's about kind of the potential for delays or a logjam, et cetera. Really important risk to align and make sure you're managing that upfront and proactively. Okay, consortia. So fun. Let's take the grant funding terms and let's make it even more complicated by adding in a whole bunch of other members. But truly, there are real benefits to consortium, and they're very encouraged by DESNZ because it helps with delivery, it helps with efficiencies of scale. It's the great way to get smaller providers involved. So overall, consortia are a very good thing. But whether you're a consortium member or whether you're the lead applicant, there are definitely things to be aware of, especially in this wave 3. So I'll just touch on them incredibly briefly. The key new thing from a legal perspective is that consortium agreement must be in place at the point you enter into the grant funding agreement. Otherwise, there is a breach of warranty. That's new. Before it was a nice to have, now it's a legally binding obligation. So realistically, given where we're at, if you're in a consortium, you should really have that agreement sort of worked up at this stage. And whether you're a member or the lead applicant, that's something you need to be managing now. There are differences, the challenge and strategic partnership route when you're looking at consortia. I think I'll touch on those a little bit more in the next slide in a kind of practical sense, but that's something to bear in mind. And just to touch on the kind of lead partner's role, I mean, of course, the lead partner will have already sort of, I guess, led on the application and gathering together all the information, et cetera. That role is even further extended when we get into contract. And that's what the consortium agreement is there to kind of set out, particularly around the level of liability and risk exposure that the lead applicant takes on. They are responsible for the delivery of the entire consortium bid vis-a-vis the funder. They take on that entire liability. So they'll need to be thinking about how they flow that down. So just in terms of kind of practicalities around that consortium agreement, there's a lot that could go in there. We've seen a lot of different types of consortium agreements. So I'm not going to get into all of it, but one thing we've already mentioned is the timing. That needs to be entered into, simultaneously with the grant funding agreement, really. There's a lot of data to be gathered both beforehand and as you go. This is the sort of SHF grant funding agreement, as anyone who's already signed up to it is aware. There's a lot of data management, much more so than you'd see in sort of a typical AHP type agreement, monthly reporting requirements, those reconciliation processes, the level of kind of information that you need to be providing at the point of claim. So that needs to be managed extremely carefully within the consortia. And there's a question of cost where we see a lot of negotiation often within a consortium. Sort of how is the lead applicant covering their own costs, whether that's for sort of putting the consortium agreement in place, for the data management, for making the applications, and is everyone happy with that? Is that seen as fair and reasonable? So those are kind of practicalities. There's the question of choosing the right structure. Hopefully you're far down the line on this one, but I mean, just in our view, we have seen, and I could see why it would be very tempting to just kind of have a very light touch agreement that basically says, lead applicant to all consortium members, you have to comply with all the terms of the GFA. But to be honest, that just doesn't work. There are areas where there are real pinch points. Things like, how does the liability get allocated between different members? There needs to be clarity around the members will only have liability for their projects, so to speak, for their element of the bid. And without setting that out quite clearly in a consortium agreement, you won't have the coverage. You'll be really exposed. Other things around the practicality of management, payment, and maybe we'll get into those in a moment. But so in terms of the appropriate structure, it needs to be beyond just sort of here's a copy of the grant funding agreement, comply with it. I guess I'd mention two structures I've seen that both I think can work quite well. One is a kind of framework style where there's a sort of top agreement, let's call it, with kind of the consortium obligations to kind of cooperate and deliver the bid, et cetera, which all the consortium members are party to, with then sort of drop down funding agreements where the lead applicant is funding each consortium member separately under its own grant agreement, so to speak. That's one. Another is a kind of all singing, all dancing consortium agreement where all the consortium are kind of have total visibility of how the consortium will operate in terms of payment, data, liability, etc. On balance, I think my preference is the latter, just because it's sort of more transparent, collaborative, but both can work and they both have their advantages and disadvantages. And just around those kind of legal pinch points. So this is, let's say you don't have a consortium agreement. What are some key things that you really want to be looking for, or make sure they're included in the drafting, or you're reviewing one that's been prepared? What are just some areas where you need to pay attention? And this is from either the side of the lead applicant or from the consortium member side. I guess the payment arrangement is really important. Obviously, that's the kind of key function in some ways of the consortium agreement. So it will need to align, obviously, with the payment mechanisms within the grant funding agreement itself, but it needs to sort of preempt those. So if you need to be submitting claims on this quite tight timescale, or in particular around challenge fund routes on specific phases, you need a management sort of system in place to make sure you're getting all that data up front from your consortium members, so that the lead applicant's not exposed and so that the wider consortium's not exposed. So make sure you've got that flow down right, and that you are building in wiggle room, so to speak, to make sure that you can make the claims as intended under the grant agreement. Same goes for that reconciliation, arguably almost more important in some ways around what happens when it goes wrong. We've mentioned risk allocation already. Things like you drop down to 9% co-funding in one financial year, you're in event of developed territory. Around the liability indemnities, again, this is somewhere it's quite different than Homes England. There's effectively an unlimited indemnity under the grant funding agreement on the lead partner. So the lead partner and every consortium member just think quite carefully how they're going to take on that liability, what's fair, what's reasonable, and if something were to go wrong, who would be on the hook, so to speak. So that balance is importantly to get strike correctly. There's, of course, the wider governance and delivery management. And you could see that, again, maybe even more important in a strategic partnership route where you have that flexibility, but that, again, will put more pressure on things like, delivery changes. You don't want to get to the end and realize that your consortium's kind of gone a bit wild and what was promised is not being delivered, because that could have real consequences across the overall bid. So you need to be managing that more proactively, potentially in an SP arrangement. Data flow, SP will have self-conducted evaluations that are obligatory. And so that's a kind of new approach that will need to be brought within the consortium agreement so that can be managed properly. And then the last one, which will lead me kind of usefully onto my colleague Stuart's area, where he's much more of an expert in some ways, but is subsidy control. When a lead partner is distributing funding under a consortium, they effectively become a funder in their own right. And depending on whether they're a local authority or whether they're an RP, there's a real impact on them as to how they do it. And this is a technical area, so that under the Subsidy Control Act, that there will be potential for them to act unlawfully unless they follow the very specific requirements under the Subsidy Control Act. So that needs to be considered. That should be covered in the consortium agreement. And there is some thinking to be done there in terms of, what is that lead applicant funding for? What's the nature of the projects? Are there leaseholders? What amount of funding are they just on granting? What's the makeup of the consortium? It will be different if it's local authorities versus RPs. So you'll need to see that covered off in the in the consortium agreement. Okay, I've just picked 4 areas. Obviously, I could go on and on about consortium. They're interesting agreements to work with because they're as interesting as the membership, and it's all about that joint delivery, which in turn is all about the individuals and organizations delivering it. I'd like to just hand over though to Stuart, who will actually pick up on this subsidy point in a lot more detail.
Thanks very much, Jess. Hi, everybody. I'm Stuart Brown. I'm a Senior Associate in the Procurement and Subsidy team here at Trowers. So I wanted to start off with just a quick introduction to the subsidy control regime and then talk a little bit about procurement as well. There is quite a lot to kind of get through in both of these subjects, so it is very much a quick canter through both of these issues. So Firstly, just to kind of set the scene then, what is subsidy control? So for those of you who have not experienced the joys of subsidy, so subsidy control is the UK specific regime that has been introduced post-Brexit, and it's essentially the replacement of what used to be known as state aid whilst we were still part of the EU. So the general test for whether or not there is subsidy is as set out on the slide. So effectively, there will be subsidy if there is a specific financial assistance which is given from public resources by a public authority, which confers an economic advantage on one or more enterprises, and which benefits some enterprises with respect to the production of goods or services, and which has or could have an effect on competition or investment in the UK, or on trade or an investment between the UK and its trading partners. Now, the first thing to note is it says on the slide there, subsidy, financial aid, which is given directly or indirectly. So that includes direct transfers of funds such as grant funding. And that is why it is so important to consider the subsidy control rules in the context of the funding. Now, it's particularly important because the grant funding here is likely to be subsidy. And I'll move on to the point about likely to be subsidy in a couple of slides' time. And therefore, the funding must be given and used in accordance with those subsidy control rules that are set out in the Subsidy Control Act. So that's kind of the context of why we're looking at it. Thank you very much. So with that in mind, then, what does the grant funding agreement say about subsidy? I've already touched on this very briefly, but there is a general obligation under the agreement to comply with the subsidy obligations under the Subsidy Control Act. So that is your kind of starting position under the GFA. We're required to maintain appropriate records of compliance. So we must make sure that we've got a good audit trail setting out that we are complying with our obligations and that we are applying the funds in a subsidy control manner. And we need to ensure that the grant funding agreement and any consortium agreement records the relevant subsidy control basis upon which the grant is given. And I'll come on to some of those bases in a moment. I think, as Jess already mentioned, there is very limited remit to actually negotiate the terms of the GFA. So there is just a little bit of thinking around when you're looking at the subsidy control provisions, just making sure that we're happy that they cover what we need it to in terms of recording the relevant subsidy control basis. Thank you. So key subsidy consideration, I think the primary subsidy consideration really is, will there be a subsidy? And the competition guidance notes from the fund when they were first published are really helpful in this regard, because they actually confirm certain scenarios where there won't be a subsidy or scenarios where there will be. So the first thing to note is that where there is funding going directly to local authorities or combined authorities, so where they are the grant recipients, that will not be considered a subsidy. Similarly, if you have a consortia that comprises just local authorities or a mixture of local authorities and combined authorities, then again, that will not be considered a subsidy within the purposes or within the meaning of the Subsidy Control Act. Slightly different position for registered providers. Registered providers will be considered to be in receipt of subsidy, so we need to make sure that we are complying with those subsidy control obligations. And again, if there are consortia comprising registered providers, they will be considered to have subsidy, and that's if it includes a mix of both local authorities and housing associations as well. So making sure that we are complying where we need to. There's also a separate consideration around the treatment of infill properties. So if we have properties as part of the bid when we submit our bid that are infill properties, so for example leaseholder properties, we just need to be mindful of how we treat those for the purposes of the Subsidy Control Act. So for example, do we need to have any consideration as to minimal financial assistance, which is what I've put on the slide there. So MFA is an exemption to the subsidy control rules, and effectively it means that enterprises are able to receive up to £315,000 in a rolling 3-year period, and that financial assistance, if it's below that level, is exempt from the wider subsidy control rules. So that's just a useful point to bear in mind. Just looking at the scheme guidance, then this again is a really useful point to bear in mind. It is worth noting that private RPs of social housing, they are not going to be limited to just that £315,000 that I mentioned under the MFA. Broadly speaking, it's likely that RPs who are applying under the scheme will be within what we call a service of public economic interest, and the guidance has confirmed that is the position. So it is just worth bearing that in mind and making sure that you carry out some sort of subsidy assessment to check that you're happy that you are within that particular route under the Subsidy Control Act. Now, generally speaking, SPEI relates to the provision of services by enterprises who are assigned with tasks in the public interest, and that includes the provision of affordable social housing. There's a wider analysis that needs to be undertaken just to demonstrate that the SPEI does comply with certain subsidy control principles, and it's going to be necessary for you as grant recipients, if you are within the scope of the Subsidy Control Act, to be able to demonstrate that going forward. And that goes back to that GFA obligation to make sure you're recording the subsidy compliant basis upon which you're receiving the grant funding. Well, so that was a very quick canter through subsidy and the key considerations that we think you need to have in mind for the grant. The next thing I want to talk about is procurement. Now, as grant recipients, very likely that you will be contracting authorities. If you are RPs and local authorities, you are definitely contracting authorities. So you are obliged to comply with the public procurement legislation when you are seeking to apply that grant funding. So what does the grant agreement say in this respect? So firstly, clause 15.4, there is a general obligation to ensure that representatives involved in the funding activities adopt policies and procedures that are required to ensure value for money. And that is kind of the key consideration when we're thinking about procurement anyway, making sure that what we're getting is good value for money. And secondly, clause 15.5, we are required to comply with the relevant procurement regulations when we are procuring goods and services in connection with the GFA. So that is a general obligation on you as contracting authorities to make sure you comply with the procurement rules. Thank you. So a couple of procurement considerations then to think about now, and these are things that we have learnt over the years as sort of lessons learned and best practice, coupled with a few new changes that Ruby's already alluded to given the change in legislation. So first of all, pre-market engagement. Pre-market engagement is absolutely vital for a really successful procurement process. Understanding who in the market is able to deliver the actual works that you're seeking to procure. Now, that's particularly the case when there are lots of people who are seeking to procure similar services. So you need to just be thinking now, as part of your pre-market engagement activity, who you want to talk to. Now, that doesn't just mean looking at the potential providers, but also thinking about actually the routes to market, which I'll come on to in a moment. So conducting some pre-market engagement with potential commercial purchasing tools, and just having a think about the appropriate ways to award contracts, bearing in mind your obligation to comply with the public procurement legislation. Routes to market then, all I really want to say is on this, there are probably three things to bear in mind. So the first is making use of a commercial purchasing tool. So looking at existing frameworks or dynamic purchasing systems, are they available? Do they cover the relevant scope and service that you require for the works? And actually, are they suitable routes for you to award contracts to? We know there are lots of frameworks that provide relevant services and works, but they have been very popular over the last few years. So there is probably a little bit of due diligence to be done on the use of those tools, making sure they still have sufficient headroom in the values and things like that to cover your requirements. Second option is to conduct a regulated procurement procedure yourself. So go out to market now, procure something, and I'll come on to the legal regime on that in a moment. It is worth thinking, if you are going to procure something, about whether you want to introduce some sort of concept of a strategic pipeline for future opportunities of a similar nature, just in case that you end up with a repeat sort of scenario in the future where you want to have somebody delivering similar works. So thinking about building that into your procurement strategy. And finally, looking at existing contracts, do you have an existing contract in place? Perhaps you awarded something previously for similar works, and do you have an ability to now modify that to make it relevant for the works needed now? Again, there's a bit of a procurement angle to that, needing some legal advice around the ability to modify public contracts during their term. In terms of applicable legal regime, as of Monday, we are now in a entirely new legislative landscape for public procurement. So for procurement geeks like me, it's a very exciting time. The Procurement Act 2023 came into force. So we are now dealing with the Procurement Act when we are looking at future procurements. But that doesn't mean that the Public Contracts Regulations 2015 that I know we all know and love have gone away completely. They are still there for contracts that we've already entered into, or for contracts that we will enter into where the procurement was commenced before the 24th of February. So there is definitely an aspect of just checking which regime applies to your contracts. Now, that's going to be particularly relevant if you do make use of commercial purchasing tools. If they were already in place before the 24th of February, any call-off that you enter into will be governed by the Public Contracts Regulations 2015 rather than the Procurement Act. So there is just a little bit of due diligence beforehand to check which legal regime we are working within. I've already touched on future requirements. That's just thinking about, are there potential or is there potential to build that into the award of a contract now if you are likely to have similar works or requirements going forward? Thanks very much. And the final thing I just wanted to note then is a couple of considerations in the scheme guidance on procurement. So applicants should consider the role of SMEs in the supply chain and ensure that barriers to participation are minimised in their procurements. Applicants are also encouraged to consider and implement all relevant public procurement notices in their procurement activity. This is broadly just a reminder of general considerations in the procurement process, particularly if you are going to now go and procure something yourself under a regulated process. That aligns to your obligations under Section 12 of the Procurement Act to have regard to the obstacles that SMEs may face in accessing public opportunities and the obligation to consider how we can mitigate or remove those risks. And there is a wider array of public procurement policy considerations that we also just need to bear in mind as well, and they're all available on the government website. So it is just worth reminding yourself of those considerations before awarding contracts. And unless I'm mistaken, I think I'm now handing over to Lindsay.
Thanks, Stuart. I'm Lindsay Whittle. I'm a senior associate in the real estate disputes team, so I deal primarily with landlord and tenant law. And I'm going to talk to you about how you can ensure that you can do the works when you're dealing with leaseholders, the best way to approach it, and to make sure that where possible you can recover the costs through the service charges. So the starting point, the leaseholders have a number of protections under the Landlord and Tenant Act 1985, which allows leaseholders to challenge the costs of works that are being charged via service charges. And so what I'm talking about really in this presentation is how you can mitigate that and try and reduce the risk of challenges so that you can recover as much as you can from leaseholders. You all know about the statutory consultation under Section 20, although I will give a bit more detail on that later on. But that shouldn't be seen as just a tick box exercise in this process. In order to make sure that you can do these works and get some money from the leaseholders, it's much better to engage early and to see the statutory consultation as part of a bigger process of engaging with leaseholders. And I put a few bits on the slide why there's benefit to that. Essentially, if the leaseholders will know the building well, they might have some concepts about its issues, things that could be improved, and the earlier you can talk to them about that and get them on board with the works that you want to do, then the more the leaseholders will understand the value of the works and be on board with what you're doing, so the less likely there is to be a dispute further down the line. In terms of how to engage, you might want to hold meetings, you might want to have specific phone lines or email addresses that leaseholders can get in touch with you through, or some kind of digital site portal where you can upload information about the works that are going to be carried out and speak with the leaseholders that way. But the key is to make sure that they are on board with what you're doing as early a stage as you can, so that they feel like they're contributing along with the social tenants and are not just an afterthought. And I've referred here to the tenant participation advisory service that's got a leaseholder engagement guide on the website, which is very helpful, and would encourage you to have a look at that. I'm going to talk about the 3 core legal considerations when you're dealing with leaseholders carrying out works to buildings. So first of all is the lease terms. Second is the reasonableness requirements under the Landlord and Tenant Act. And third is the Section 20 statutory consultation. So the lease terms, essentially the lease is king, and it's worth bearing in mind that all leases are different, and this should be the starting point, is to make sure that you are reviewing the lease terms for buildings where works are going to be carried out. The first thing you're looking at is what the landlord's responsibilities are under that lease. So what are you obliged to do? What can you do? And what separately can you recover under the service charge? So if you're carrying out service, you're repairing something, you're carrying out works, can you recover that under the service charge? So a lot of leases will have repair and maintenance obligations for the landlord. Some leases might specify that you can carry out improvement works, even if that scenario, there is a clause that says that is often worth bearing in mind that will still be subject to reasonableness. So the works it doesn't give you carte blanche to carry out any improvement works you like. They still have to be reasonable and in line with the repair and maintenance obligations, really. The replacement is normally to a modern standard, but that again doesn't mean that you can just replace everything where it's not in disrepair. So it's really worth looking at the lease wording and the works that you're going to do and whether they align. And then the service charge obligations, to make sure that what you want to do is covered by the service charge, which I said before, because if it isn't, then you're not going to be able to recover it, and the leaseholder is going to challenge those costs. What we will also find in the lease are access rights. Normally, most leases will contain a right for the landlord to go into the premises demise to the leaseholder in order to facilitate works to the common parts. And it's worth looking at those in detail, making sure you know what those are. There'll often be notice requirements if it's not urgent work, so you might have to give a certain amount of notice to leaseholders before you can access. And if the leaseholders, one of the problems that you can encounter, of course, is that leaseholders will refuse access even where there's a right to do it. How do you enforce that? Well, the main way to do that, and a slightly nuclear option, is to get an injunction from the court. But if you're not able to negotiate with the leaseholder to let you in, then that might be a last resort. That obviously will add time and cost to the process. So again, it's worth knowing up front what your access rights are and making sure that you carry out that process properly. So reasonableness, if you're charging service charge to leaseholders, then under Section 19 of the Landlord and Tenant Act, those costs have to be reasonable. That means they have to be reasonably incurred, and that the work that you're charging for is of a reasonable standard. So you have to meet both those criteria. And one way of looking at it, which seems fairly obvious, but is to make a decision on the cost as if it's your own money. And sometimes in these scenarios, a lot of it will be, because you'll be funding the social element anyway. But the courts or the tribunal will ask, if you weren't willing to pay that money for that level of service and for those type of works, then why should the leaseholders? So it's a fairly common sense approach on what is reasonable. That's a challenge that leaseholders could make. If you've got something that you think is going to be particularly contentious, there are going to be some costs that might be challenged. Then you can go to the first tier tribunal before you incur the cost to get a determination that the costs are reasonable. That way you'll know that what you're doing isn't going to be challenged later after you've paid out all that money. So that's just something to bear in mind that you can do. So moving on to Section 20, I'm sure you'll all be familiar, but I'll give a bit of an overview on how it works. The objective of the statutory consultation is to make sure the work is appropriate and that there is quality and costs of the work are reasonable. One thing to bear in mind is that even if you carry out the consultation process properly and follow everything correctly, that doesn't mean that the leaseholders still can't challenge the reasonableness of the costs down the line. But if you've done the consultation properly, it will give you some arguments in a better position if there is a later challenge on reasonableness, because you'll be able to show why you made a decision on certain contractors and that the leaseholders had oversight over what those costs were up front. So Section 20 applies to qualifying works, which are major works to a building. Major works to a building where each leaseholder is going to have to pay over £250. And also applies to qualified long-term agreements, which is any contract you enter into that's over 1 year and for which each tenant will have to pay over £100 per year. You might be carrying out just works with a contractor, or you might be entering into a contract over a longer period of time for work over different phases, for example. So you might have to consider quite carefully if you're doing qualifying works or entering into a qualified long-term agreement. That's something to get advice on before you proceed to serve any Section 20 notices. If there is an issue with the consultation process, or because of the urgency of the works that need to be done, you can't carry out the consultation process, there is the ability to apply for dispensation from the tribunal. Often whether or not you can do that, whether or not you'll be granted dispensation, depends on why you haven't carried out the consultation process and what the prejudice is to the leaseholders. So had you have carried out the consultation process, would there have been a different outcome? What would the leaseholders have done differently if they'd have been given those the opportunity to make observations along the way? Dispensation can be quite costly, and you often have to pay the leaseholders. If it happens because the leaseholder makes a challenge, then you'll often have to pay the leaseholders costs as well. It's worth bearing that in mind. So I'm going to very quickly talk about the different types of Section 20 consultation from a qualifying works perspective. Sorry, Ruby, could you just go back for 1 minute? That I was just going to mention that there are two regimes depending on whether public notice is required. So basically, if the cost of the works meets the procurement threshold, and that's the number that's on the screen, so the 5,372,609, inclusive of that figure, and that's reviewed each year in December, I believe. So if your work's going to be more than that, then you'll be in the public notice section. Basically, the difference is that you don't have to ask, there's no requirement or ability for the leaseholders to suggest contractors, whereas if you're under that threshold, then there's another there's basically a step where the leaseholders can suggest contractors, and you have to get quotes from them if you can. For both sets of notices, if it's public procurement or not, you'll have to serve a notice of intention setting out what the works are. Then the leaseholders will have the opportunity to respond to that with observations on what they think about those works being done. You'll then have to send what's called a contract statement here, or a notice of proposals setting out the contractors that you're suggesting to be used. If it's public notice is required, then you won't have to give more than one. If it's not, then you have to give at least two, and any that the leaseholders have suggested have to be considered. And again, then the leaseholders will have the chance to comment on that and give their views on the costs that are being proposed. And then after that, you have to give notice of the contractor that's going to be used. If you could just flick through those, Ruby, there are 2 more slides. So the final thing I'm going to talk about is grant funding and service charge recovery, because there is these directions that are on the slide there, the Social Landlords Mandatory Reduction of Service Charges England Directions 2014. They came into force to try and protect leaseholders from excessive charges. It's known as Florrie's Law because it was brought in after a case involving an old lady called Florrie. And essentially those directions limit the amount that a landlord can charge leaseholders, as you can see, to £15,000 in London, £10,000 out of London in any 5-year period, where the costs are incurred partly or wholly with relevant assistance from a government programme. It's not very clear whether that means it's a cumulative cost over the 5-year period, or whether it's just one set of major works for which you're using assistance. If you're not using assistance for the rest, then they don't outcome. There haven't been any cases since that clarified that in the court, so it's quite open to interpretation as to how you do that. And the unintended consequences of this law is essentially that sometimes you could be applying for grant funding to do the works, and actually, because that limits what you can then recover from the leaseholders, you're left in a position where you as a landlord end up paying out a lot more than if you actually hadn't applied for the funding in the first place, which is clearly not the intention of the direction, or it's certainly not something that was anticipated at the time it was brought in. And so you might want to take advice on how to structure your works and the best way to do that if you're receiving funding.
Okay, lovely. Thank you very much, everyone. Just wanted to say thank you so much for the presentation. I definitely learned something. The contact details are on the screen. Please do feel free to visit the RISE website as well. We've got lots of other resources on there. But thank you very much for your time today, everyone, and hope to see you at one of these again soon.